Patricia, and thank you to the MIT Club of Northern California for organizing today's exciting event. As Patricia mentioned, my name is Josepher Lee, and I currently serve on the board of the MIT Club of Southern California, and I'm a member of the MIT class of 2013. By way of background, I am a patent attorney at the litigation firm ARMOND Wilson in Newport Beach, California, focusing on intellectual property disputes and litigation. And with me today are two of my colleagues, Michelle Armand and Doug Wilson, the founding partners of Armond Wilson. And today the three of us will present some insider tips, patent tips for startups. In many ways, patents can be one of the most valuable assets for a startup company because it can help establish your niche in the market and eventually help drive valuations and help motivate potential acquisitions. Now, the three of us, me, Doug, and Michelle, we don't prepare patent applications, at least not anymore, but we do handle patent disputes and litigate patents, representing both patent owners and defending against patent assertions. And today we're providing, again, some tips and strategies for how to make the most of your patents based on our experience putting patent portfolios to work. We love questions, and we'll try to leave a couple of minutes at the end for questions. But please do feel free to type questions into the chat box below as we go along, and we'll certainly try to answer as many of them as we can at the end of today's presentation. So with that, let me go ahead and turn it over to Doug Wilson, who will kick us off.
Thank you, Josepher. So I'm going to start by talking a little bit about trade secret versus patent protection, and just for anybody who's not familiar with these, these are protections of ideas as opposed to something like trademark protection, which would be a protection of a designation of origin like AMD or Intel or Apple or Samsung, or also in contrast to something like copyright, which is a protection for works of authorship fixed in a tangible medium of expression. Think like a book, a song, a video, a web page, or things like that. So we're talking about ideas here. So the question is, trade secret versus patent protection. In some areas, this is a simple determination. In other areas, it's quite complicated. But just at a basic level, trade secrets protect things that you've gone to some effort to some reasonable measures. You've taken reasonable measures to keep them a secret. And in exchange, you can protect them indefinitely. However, the protection is quite limited. So your protection is basically against misappropriation. That means somebody wrongfully taking the idea from you. So if somebody independently develops it, or if they, for example, reverse engineer your product and figure out the idea, then it's public and you can't stop them from doing that. So the protection is limited. With patents, however, you get broader rights, but a limited duration. And also, you publicly disclose, right? The exchange of getting a patent requires you to publicly disclose how to make and use your invention, but you get a term that's typically 20 years from your patent application filing date. So if someone reverse engineers a product, if they come up with it independently, you still have rights against them with a patent. So the rights are much broader, but the term is limited and it requires public disclosure. So there are a couple of areas, I would say, where things are pretty clear what you should get. The prototypical example for a trade secret is the formula for Coke. You get indefinite duration protection, and all you have to do is keep it a secret. And that seems fairly straightforward choice. Pharmaceutical drugs are a great example of something that is ripe for patent protection. You're basically going to have to disclose what's in the drug publicly to get FDA approval anyway. And the pharmaceutical drug regulatory scheme is just really favorable to people who have patents. So, but a complicated area is software. Software is something that you can sort of keep secret. It's possible to disassemble object code, and it's possible to reverse engineer it, but it's not that easy. And at the same time, you can get patent protection for it. But in the last, I would say, 5 to 10 years, patent protection has been hard to maintain for software. And courts have been striking patents down as abstract, or software patents in particular, down as abstract ideas. And I wish I could tell you what an abstract idea is. No one can, which leads to the uncertainty around software patents. And that leads me to my next point, which is if you're interested in patents or you want to pursue a patent application, my highest and best recommendation is hire a patent attorney. It's worth the money. The second point I would make there is hire someone who understands the technology. And the reason is because patents, especially if you want to actually use them and enforce them, it all comes down to what we call the written description. There are two parts to a patent. There's a description of how to make and use your invention, and then there's a collection of claims at the end, which are numbered paragraphs that define sort of the fence around your property, what we would say the metes and bounds of your invention. Someone who does what is in a numbered claim infringes your patent. Well, that all comes down to that written description, how you interpret that claim. If you need to amend the claim, it all comes down to what's in that written description. So that leads into my next point, which is if you're going to have a patent, you might as well have a good one, because it doesn't do you any good to have a bad one. Filing patent applications is not cheap, it's expensive. So if you're going to spend that money, you might as well spend a little more and get something that's valuable, something that's worth having. So the first way to do that is to invest in someone who understands the technology and can prepare that detailed and comprehensive disclosure. That's critical. And the reason, as I said, is because the claims define the metes and bounds. And when you have to amend your claims during prosecution, after you file your application, it all comes down to what's in that written description and how detailed it is, because the examiner is going to search for prior art. The examiner is going to reject your claims based on prior art, and you're going to have to amend. And when you do, it comes down to what's in that disclosure. What can you amend? How can you narrow your invention to avoid the prior art that the examiner has found? It all comes down to what's in that disclosure. So, and that leads to the final point, which is it's a great idea to investigate the prior art. It costs a little more. It's you have to spend some money to do it, and typically the way it's done these days is even law firms will outsource this to a prior art search firm, and it will cost several $1,000s to get a good search. But what it gives you is an idea of what the examiner is going to find after you file your patent application. That leads to the ability to draft a better written description, a better and more comprehensive disclosure of your invention, knowing what the examiner is likely to find and what you're going to likely have to get around. And it also leads to better claims, which are the boundaries around your invention. You want to draw that fence so that it doesn't encompass any prior art, because if it encompasses prior art, it's invalid. And so investigating the prior art makes perfect sense, and it's worth the money. So those are my tips on trade secret versus patent protection, and a few tips about patent protection. And are there any questions at this point? And if not, I'll turn it back over to Joseph.
Great, thank you, Doug. As Doug mentioned, it's important to invest in your intellectual property, including by obtaining a strong initial patent. But oftentimes what you'll find is that having just one patent is not enough. In fact, in many cases, you'll find that it's both necessary and in fact, highly desirable to file and maintain what are called continuation patent applications. And so that's much of what this middle stage here is about. So what is a continuation application? Continuation application is basically a new patent application that claims priority to an earlier filed application, and that allows you to pursue additional patent claims based upon the same subject matter disclosed in the earlier filed application. And now the fact that the continuation has the same priority date as the earlier filed application, that's the key. The earlier your priority date, the less prior arts you have to be inventive over, and the better your chances of obtaining a patent with your desired claim scope. Now, this is, admittedly a bit abstract. So here on this slide, I provided a diagram that shows how this might play out in practice. So if you look at the top left of the diagram, you start with a patent application that's being examined by the patent office, and that's currently pending. And before that application, which I'll call the parent, goes on to issue as a patent, you file a continuation application, which I'll call continuation application number 1. And so what you have is this: the parent goes on to issue as a patent having some claim scope, which is represented symbolically here by the bullseye. You also have pending continuation application number 1, which claims priority back to the parent. And so the reason this is incredibly useful is you can use continuation application number 1 to obtain additional claims that have a different scope than that in the parent. And as shown in the diagram here, you can continue this process by filing additional continuations, so long as at least one application in the priority chain is still pending. So there are many reasons for filing and maintaining continuation applications. And one reason is to pursue broader or just different claim scope. Oftentimes the initial set of patent claims you obtain may be fairly narrow in scope. And so you can use a continuation to pursue broader protection. In other words, claims that are a bit broader in scope. Continuations can also be used to protect variations or alternative embodiments of your invention, or to block design arounds, so long as, of course, those design arounds are described in your original patent application. So what do I mean block design arounds? Well, sometimes a competitor will try to design a similar competing product that avoids falling within the scope of your patent claims. And they might do that by making minor changes to the design of their product. And so what you might want to do there is pursue continuation claims that cover those minor changes, as well as other variations of your product. Now, as you can imagine, of course, it's in general, it's very difficult to predict, what claim scope you might want in the future, because you just don't know what the competitors are going to be doing. And so for that reason, it's critical that you monitor and adjust your claim strategy as necessary, and having one or more continuations pending will enable you to do that. Now, over time, hopefully what you'll see is that by pursuing patent claims that cover different configurations and that have different breadth, you can start to thoroughly cover a particular market or technology using your patent. So yet another reason to pursue continuations is to use them offensively. In other words, you can file a continuation specifically to pursue claims that cover a competitor's product. Keeping in mind, of course, that if you want to draft claims to cover a competitor's product, those claims do need to be supported by your original patent application. And finally, continuations are, in fact, fairly standard tools for patent owners engaged in or contemplating litigation. So for example, if you sue an accused infringer and they come back and identify prior art that was previously unknown, well, now you might have an invalidity problem. Your asserted patent may be invalid. But if you have a continuation still pending, what you can do is draft new claims that may overcome the prior art. And of course, that will put pressure also on the patent defendant. So, long story short, continuations are a pretty flexible tool. They can be used to further quite a number of different business objectives, including preparing your patents for assertion against accused infringers. So with that, let me go ahead and turn it over to Michelle Armand, who will discuss the last and final stage, the assertion stage.
Hello, everybody. This is Michelle. Can you actually see me? Because I can see Josepher.
We see you. I hear you.
Okay, great. So this is our kind of more mature stage of the startup. So if you make it this far, congratulations, you have a very successful startup. So this is kind of things you think about further along after you've already kind of made these initial determinations and invested in your patent portfolio. So you're kind of at this stage at the point where maybe as a company you're considering getting acquired, or you're thinking about starting to assert your patent portfolio against existing players or new competitors, or, and this is a sign that you're truly successful, you're now rising in the marketplace and more established players are starting to take notice and they are starting to come after you with various intellectual property claims. So this is kind of the point where we show up because disputes are arising. So what I hope you've taken away from the earlier presentations is an ounce of prevention is like a pound of cure at this stage. Like if you have done a good job on your patent portfolio, this stage gets to be a lot easier. So if we move to the next slide, these are sort of the considerations as you're, turning towards the dispute phase. And I'll just say from our own practice, having a well-prepared patent portfolio can provide incredible market strength. I had a case for a very well-known Silicon Valley startup who really came up with an incredible invention, and then of course everybody ripped it off. And they were in a David versus Goliath scenario where they either had to prevail on their intellectual property rights or they were going to go out of business because everyone had just ripped them off and paid them nothing. And in defending this patent portfolio, which had been written by a fairly inexperienced patent attorney up in the Bay Area, we definitely spent probably millions more litigating issues that could have easily been fixed with a stroke of a pen 5 years earlier when they had been prosecuted. So just spending a little bit more money up front is going to save you a ton of money on the back end. So as you enter this stage, if you have these continuations pending or whatever your existing portfolio is, you often will continue to refine your portfolio even through litigation. We have clients that are refining their portfolio at year 19 of the 20-year patent term. Having those around is incredibly useful. And for companies that are looking to enforce their patent rights, we, the litigators, come in and evaluate the portfolio, and we're really looking for what I like to call the Goldilocks patent. It needs to be broad enough that you can actually establish infringement, either to enforce it or to defend against claims against other people as kind of a more defensive tactic. But it can't be so broad that it's invalid, because if your patent is too broad and it reads on the prior art, maybe even things that you didn't even know about, it's not going to survive the inevitable validity challenges that we're seeing. And these come now in multiple flavors. So, traditionally patent cases are litigated in federal court, and you deal with all the issues there, infringement, validity. But now, if you're trying to enforce your patent, there is a collateral attack that accused infringers can bring. And now we actually are litigating in the patent office itself. So the same group that issued your patent, defendant can, or anyone actually, can bring you back to the patent office and file a validity challenge there. These are actually relatively new. They were introduced by legislation called the America Invents Act back in 2012. And there's a variety of these, but the most common one is called Inter Partes Review, or IPR. And these are fairly routine now in litigation. So people will both be litigating in federal court, and then often we'll have a side case in the patent office. And the IPR proceedings are different, because in federal court, you are presenting your case to a jury of ordinary people that will decide all of these issues. But at the patent office, it's actually what's called an administrative proceeding. So it's not tried to a jury, it's tried to a 3-judge panel of expert judges that are not just experts in the technology, but they're also experts in patent law. And as you might suspect, those judges are a lot more skeptical than your average jury about patent validity. So there's a higher rate of invalidation in IPRs. And that is why having a strong portfolio, having claims that cover a variety of scopes, having claims that don't just necessarily cover your software or your commercial product, but maybe on ways that you deliver it to customers or your manufacturing or the accessories that go with it. All of these things are something that if you hire a good patent attorney and have a great patenting strategy, have hopefully already been accounted for. But if not, you can still use your continuations to sort of get the coverage that you need. But even if you don't have pending continuations, because frequently we see clients and they have 1 or 2 patents and that is it. There's another proceeding that you can use that's also in the patent office, which people don't really know about, and that's called reissue proceedings. And that's where you, as the inventor, voluntarily go back to the patent office and you can change your claims. If you do this early enough, you can actually broaden your claims somewhat. But if you're past the deadline, these can be useful because you can get narrower claims and avoid, potential prior art if you have a prior art problem. The disadvantage of this compared to just having a patent portfolio that's still alive with pending continuations is once you change your patent, you cannot go back in time and collect damages. So once that reissue issues, you can only kind of address future infringement and you cannot go back and claim damages for past infringement. So that's a big disadvantage. But in the right circumstance, a reissue can actually be very, very useful. Now I'm seeing that we have a question in the chat box. So Stan is asking, what are some considerations if you have a patent portfolio, you've identified infringers, but you do not have the funding to pursue litigation? Well, that is the $1 million question these days. Doug, do you want to address this or do you want me to say something? I think Doug has gone MIA. There he is.
Let me unmute myself. So yes, I can start and then you can follow up. So this is a very, very, very common situation. And, we field calls constantly from people who have this exact situation. There are a number of options that are available. So there's a body of litigation financiers that we would call funders who are willing to look at your portfolio and invest basically and say, we'll loan you the money. Or actually, it's not a loan. They will pay the money, the expense of litigation. They'll hire a contingency fee firm or they'll pay the firm, which is very rare. Typically, they hire a contingency fee firm to litigate. So the firm takes part of the risk, the funder takes part of the risk, and both of those will take a cut of any recovery. So that's typically the way it's done. There are other ways it can be done, such as there are a couple of organizations that are very prominent now that also come out and they'll purchase the portfolio from you and they will litigate it and give you a back-end interest. So there's a number of ways this is done and both of those ways are quite common.
I'll just jump in. I have some more thoughts. It used to be very common to do this or to find contingency firms. Now with these IPR proceedings that I discussed, it is more challenging because unless you really have some rock solid patents and you have infringers and there is a big damages claim, it is more difficult now to find a funder or a contingency firm. Just because there's so much risk that you won't get to the end and something might go wrong for you in the patent office. But it is, if you have a solid patent portfolio, people are still doing this and absolutely monetizing even as, small individuals or small companies. Okay, we have another question from John, which is, what do you do if you assigned a patent to a company with a separate royalty agreement? They violate the terms of the royalty agreement. Is there any recourse to have the patent assigned back to the inventor? So if you're in that situation, usually those tend to be breach of contract disputes that are not even handled in federal court. They're handled in state court, but it does depend on what the terms of the contract are. So that actually might be a possibility. Probably at the very least, you can actually get them to pay the money that you're owed, or otherwise, compensate you for the damage by violating your contractual royalty agreement. But it's really going to depend on what the specific contract says and what the alleged breach is.
Yeah, and let me add to that, don't wait. Waiting will only harm your rights. So if you have a problem, you need to do something about it, because the longer you wait, the less likely you are to get any recovery.
Yeah, and that's actually true also if you have someone that's violating your patents as well. So when you file suit, you can go back up to 6 years to collect past damages, assuming that you have a patent enforced during the 6 years. But that window is constantly rolling. And I've seen clients where, things have changed and people are no longer actually violating their patent. And so that window of damages is constantly closing. Okay, we have a question from Chuck, which says, can you rediscuss the issue about the date associated with the continuation? So that was a point that Josepher was talking about, and that this is the magic of continuations. So with a continuation, you can get new claim scope, but if you have support in your earlier application, you can actually go back to the priority date of your original application and therefore avoid all of the things that have happened in the meantime, which normally would be prior art if you filed it as a brand new application. So that is the magic of a continuation. All right, and then we have a question here for Josepher. Are the costs of a continuation patent application the same as the parent application?
So if the question is, are there additional costs to file a continuation? The answer is yes. You do need to file a new patent application and pay the associated fees to the U.S. Patent Office for that. In addition to that, you will typically need to pay, obviously, attorney fees for preparing the continuation. Now the fees for preparing the continuation are fairly nominal compared to preparing the original application, but obviously during examination of that patent application, there's typically a back and forth between you, the applicant, and the patent office. And so responding to those inquiries by the patent office will typically cost you in around a couple thousand each time. So I'm not sure if that answers your question, John.
Joseph, you want to read these new questions from Mark?
Yes, it looks like we have a new question from Mark, which is, does this continuation extend the duration of the original patents or continuation patent only on still based on the original patent? No, it's still based on the original patent duration. So if you file, let's say you filed the original patent application back in the year 2000, well, typically your patent term is roughly 20 years. So it would expire in 2020. So if you file a continuation in 2019, and let's say it issues in 2019, you'll have about 1 year left of patent term. So it's based on the original patent filing date.
Well, I think that about wraps it up unless we have more questions. I just wanted to say thank you to everybody. And I am wearing MIT regalia because my husband said if I did, he would make dinner and I cannot pass that up. So thank you, everybody.
Yes,
so if he asks, I did it.
Thank you.
Thank you. Thank you for the great session. Very informative. And that means